Good morning, students. First, set my apologies for not being able to run regular sessions with you as I would have loved to do. I've not been well for some time, so I'll just slow down a little bit. But the few days before you write on Friday, I thought I should make myself available to you so that maybe through some questions and answers or Q&A sessions, you will still be able to make some progress. So as I posted on the various platforms yesterday, what we are doing today, and we'll be doing a bit more before you write on Friday, is what they call the Q&A sessions. So the protocols or the rules of engagement. Please, somebody is already breaching the rules of engagement by leaving his mic on. So I'm going to lock the mic. So you first have to raise your hand to prompt attention of the facilitator or the tutor. And then once attention is prompted, you will definitely be called upon, or your mic will be released so that you ask your question. Ordinarily, I have loved to leave all the mics on, but it appears some of you keep forgetting yourself and leave the mic on, which is no good. So let me lock it. When you raise up your hand, then I will release it for you. I think that's better. So the second one, so you ask a question in a very respectful manner or comment, and then you wait for response to your question or comment before another one is taken. So that is going to be the rules of the engagement. Yeah, so having said that, the floor is open for you to bring up your issues and concerns and all that. So while waiting for anybody to come up, based upon interactions I have with some of you or based upon some observations, which examiners have made, I will also be throwing comments. So just to repeat what I have said before in some other sessions, per the new rules, you're supposed to answer 4 questions out of 6, okay? And there's nothing like compulsory question as far as the rules that the publish are concerned. So what that means is that all questions carry equal mass. An implication of saying that all questions carry equal mass also means that if you decided to spend all the period or half of the period answering only one question, even if you were fortunate to be able to write an answer which coincide exactly with the marking scheme, your examiners cannot say that you should be given marks for the other questions that you haven't answered, as you should know. So if there's a 25 marks for a particular question, of course, which should be the case if they are going to use the 100 scale, or 50, they are going to use the 200 scale for the 4 questions, whatever it is. You can be given only that for that question. So please be balanced. Be balanced in your work approach. If I say balance your work approach, that is to say that don't allocate more than what is necessary to one question, knowing that you cannot get even the total marks for that question, regardless of the quality of your response. This is not a quantitative assessment or mathematics. So even with the best of effort, if it's 25, there's no way they will give you 25, probably maximum. 22 or 23 over 25. So what is the point of you ignoring other three questions, or by not giving enough and reasonably equal attention to them so as to also earn something across board? So that is first advice I want to impress upon you. So you go there, you say questions, quickly read through the questions. And then when you read through the questions, how do you make the choice as to which ones you are going to answer? You ask, don't, of course, the temptation is there when you have, you probably see just something small in a particular question and you think that, okay, I've read that one, so I'm going to do that. No. So there's something we call putting your best foot forward, right? Because this is a competitive examination. That is to say that we are using these exams to select who will be admitted to the Ghana School of Law 2024 academic year, as it were. So you want to go for question which you understand it very well. So that is the first thing, understand it very well. It's not just a question of what you have learned. Because if you've learned something and you don't understand the question well, despite the fact that you have learned it, you may not be able to write the required answer in a way which will enable you to get the maximum marks or reasonable marks, which will work towards you passing the exam. So please pay attention to that. So you have to be guided by that. Do you understand what the question is asking me to do? If you understand, then ask yourself, okay, if I understand all that the question is all this is asking me to do, which of them do I think I can do it very well so that I get the good marks? So that is it. So once you have settled on it, the other advice is that don't start answering your selected question one or your selected question two. I'm not saying question number one or number two. I'm talking about like the ones that you have picked. Your selected question, first question or second or third or fourth question. If I were in your shoes, what I would do is that when you go to the exam, so a lot of things are still fresh in your mind. And over time, if you get carried away by answering a particular question, maybe some of the things that you have learned may become a bit blurred and so on. So to guard against that, if I were in your shoe, what I would do is that when I enter the exams hall and I've read through, they say start work, I've read through all the 6 questions and I have reflected and then come to an informed decision regarding which of them I think I can do so as to get the very good marks to enable me pass the exams and go to law school. I will take all the four, one after the other, quickly do what I put the points down, okay? So you are choosing first question. You quickly put all the points for answering that question down. You are choosing second question, you do the same thing. You are choosing third question, do the same thing. You are choosing fourth question, do the same thing. And you can just write on top answer draft, and then I haven't seen your answer booklet, but if I'm sure most examination, it will be permissible for you to use part of the the answer booklet. Maybe you can even use like probably the first page or the first 2 pages to do that exercise, and then all that you have to do is to rule out, right? You cancel the paper. No, I mean you cancel the page or the 2 pages that you have used to do that rough work, as it were. Now, the benefit of proceeding in that way is that you minimize the risk of getting stuck. When you have finished answering, let's say, your first two selected questions, then the third, fourth question is not forthcoming. So you minimize that risk because you have already put the answers down, and so you have put the points down. So once you go back to the points, it will definitely trigger what you know and be able to flow with the response. So I think that is a good way to proceed. And again, as I said, you can time yourself. How long is the paper? Is it the 2 hours or more? Anybody? Anybody remember the rules? Okay. Lord. Yes, Lord Catus, you can.
Yes, Doc, good
Yeah.
morning. Respectfully, please, it's 3 hours.
Oh,
Few
3 hours.
hours.
Okay,
Yes,
good.
please.
Good. So 3 hours. So if you have to do 4 questions, I think effectively. So 3 hours is like 60, that's 180 minutes. So oh, is that correct? Yeah, 180 minutes. So if you divide that by 4, um, you're probably looking up to roughly 45 minutes per question. Yeah, so you can even time yourself and use 40 minutes, right? Use 40 minutes for answering a question. So once you use 40 minutes in answering a question, you've timed yourself regardless of what. Once you've done 40 minutes, just leave it. Go to the next question. Because what examiners observe is that examiner may take a script and you get a student who has answered, let's say that the 1 or 2 questions, let's say in the past when they're doing 2 questions, a student who has answered, let's say the one question very well, and he or she may even be getting close to the, if you like, the maximum marks allowed for that question. But you move on to the next question, and it's a huge disappointment in the sense that someone who has been able to write a very high quality, response to his first question, the second question is nothing to write home about, and you begin to wonder: is it the same quality of candidates? You see, avoid that. So the sad thing is for a student to be excelling one question and to fail the paper. And especially those of you who have been writing the law school entrance examination more than once, some of you fail, not because you are not good, no, because of the wrong approach, lack of balance. You have to respect the rules of the engagement, the rules of examination, and answer all. So that is all. Okay. Now let's get to some substantive stuff. And again, let me also I'm still waiting to see any hand up, take any question or comment, and then we discuss, because that is a sense of me coming here. The other thing to remember is that, let's say that if you have a question from constitutional law, okay? If you have a question from constitutional law, and let's suppose that the question is asking you maybe to discuss something relating to maybe the, let's say, parliament passing a particular, for example, just like the LGBT or the proper, the sexual and family values bill, which has been passed. And let's say the president yet to assent to it, assuming you are discussing something around that. Now, in terms of referencing the Constitution, okay, your marking scheme, for example, in some cases may expect students to, for example, discuss some constitutional provision as it were. But let's suppose that you don't remember anything like, yeah, I'm teaching online. Yeah, right. Okay. So let's suppose that you don't remember anything like Article 106, okay? But let's say you know the procedure for passing a bill into law very well. And what you know is exactly what is reflected in Article 106, among other things. Please don't force yourself to write Article 94 or Article 64 when you don't remember Article 106. It will be enough for you to say that according to the 1992 Constitution, the president can do XYZ, or the president may not do XYZ, or so and so may be done. That will help you to get credit rather than you stating the correct thing and putting the wrong constitutional provision there. So that is another thing I wanted to remind you. And of course, the same thing also apply to the criminal law, as well as land law, especially when we have the Land Act. So you only state the exact session when you are 100% sure, or yeah, that is it. Or if you are not very sure, when you state it, you can have a bracket and then put like the question mark against it, suggesting that you are not sure of the correct number. Yes. Any substantive question or comment? Okay, let me see any hand up. Yes, okay, let me see. Which one is up so that I will release the person. Question, quick one. Okay, I think you can release yourself now. Yes.
Oh, my lord,
Yes.
with reference to what you just spoke about, does that not suggest to the examiner that you are uncertain of what you're writing about?
Okay. So what, for example, you've written that in a person, may go to Supreme Court and seek a declaration that's anything done or omitted to be done is unconstitutional. Okay. You've stated that, and I say see Article 3 of the 1992 Constitution. Certainly, Article 3 of the 1992 Constitution does not say that. It's rather Article 2, isn't it? So, two ways. I would have preferred you not even stating Article 3 since you are not sure. Then we just say that according to the 1992 Constitution. But then, if you still want to take the risk and think that, yes, you know everything. So you say Article 3, but not very sure. Then you put into bracket, let's say like a question mark, suggesting that you are not sure of the number, like the particular reference. But to avoid all that complexity, I mean, it will be prudent if you avoid the numberless Article 3, since you are not sure of it, and just say that according to the 1992 Constitution, so and so and so and so may happen that way. Yes. Right. Yes. Thank you, Kojo. I think we have another hand up. Yes. And then Henry can release himself. I'm sorry. Yeah.
Good morning, my lord.
Good morning. Those let me say that those who are on the other platform, I think the account I am using, I don't know, I think I suspect it can probably not take more than 100. So maybe when you leave, you may not be able to come back again, because if it gets full, it gets full. But then when we finish, I think on the Ghana Law TV, we upload the recording there. So those who are not able to join can play it back. Yes, please go ahead.
Good morning, my lord. Please, per the rules of the exam, are we expected to at least make half of the marks per question to pass that particular question?
To be honest, I don't have the rules now with me at where I am. I'm not in the country, so I don't have like with me, so I'm not able to speak to that, but save my recollection from what I read when it was published in the newspapers. Yeah, but I think that without even being sure, I would say that if it's 100 marks, you're supposed to get 50. I don't know whether they will say that you should pass all the, the four, questions, but you and I preparing and working towards the paper. And that is why in the beginning, I talk about you being balanced, being balanced in your approach. That is to say that don't concentrate on, just only one or two questions, but you must respond to all the four questions. Of course, you may not get equal marks since your strength may be better at some of them than others. That is understandable, but don't mess up in the two other questions. I think that is a safe thing to do. But in those who have access to the publication, they can share with us, and then we'll look at exactly, or somebody can read it and share what the rule says with us. Okay, so we take one lady and then we come back to Mr. Salisu. Okay, Abigail.
Please, good morning. Please, I would want to ask, when writing the index number, are we to write the EE24 or is just the numbers we are supposed to write?
Write the EE24, write the full distance, the full index number that will be given. And please, write it well, because we know instances where some students, I don't know, see, that's why, of course, we understand pressures and tensions or stress, which every examination candidate face. And some can even get so agitated that when they get to the exam, so they practically experience a mental block or blackout and things like that. We pray that God delivers all of you from that. But the way to manage some of these things is your examination number or the candidate number. That is your identifier, right? That the examination is a system. So how does the IEC, the Independent Examination Committee of the General Legal Council, how are they able to identify you? It is through your index number. They don't use names. They don't use names, just the index number. So please write the numbers will be given properly. So the numbers that you will be given, I think, upon your registration or whatever, that is your identifier. So you don't have to pick and choose which aspect of it you are going to write. Write as you will be given. So that is important. And make sure that you don't make a mistake. Because if you make a mistake, imagine you are, let's say that 2,000 or 3,000 or almost 3,000 people writing the exams. I don't know the number now, but we'll know I think Friday going. Now, if you make a mistake with your index number, okay? If it's a professional exam, let's say that if it's like the bar exam, you're already in the law school, part 1, part 2, the system may be of course, the system will be angry with you, but it may be a bit more tolerant with you than you, someone seeking to come in. Because mind you, at this stage, the system does not owe anybody obligation. No wonder there's even a rule that when you fail, you cannot ask for remarking, because this is selection exams. Remarking for what? So make sure that you follow the instructions. So if basic things are writing your index number, right, or your student number, you are not paying attention to it, why should the IEC or those who manage the process, why should they suffer only because of you, when there are over thousands of students, seeking to be admitted, and they have done the right thing? So please, don't, you'll be working very hard the past few months, and some of you in the past year and all that. So don't let your hard work become useless just because of avoidable minor slips, not to do with the substance, but to do with the process. So let's pay attention to that. And the same thing also applies to question numbers. Usually in examination, we have a box, usually at the beginning of the answer booklet. Most answer booklet, I haven't seen your answer booklet in a long while, where we indicate the question numbers that you have answered. So if you've answered question 2, you write question 2, then you come and write question 2 at the that particular box. Some of you in exams will answer the question without writing the question number, even at the top of where they've written the answer, so that when the examiner takes the script, the examiner does not know which particular question, and the examiner will have to know. At some examiners conference, there has been a debate some time ago somewhere as to if the student has not written. So the debate was in two dimensions. One dimension was that if the student has not written the answer number against has not written the question number against the answer that he or she has provided, should the examiner having looked at the questions and the marking scheme, settle on the particular question that the student has answered and write the correct question number against it for the student? So that is one dimension. Now, the other dimension has to do with where the student has written the wrong question number against supposedly right answer. So that one too, let's say that the student has answered question 4, but mistakenly wrote question 6. But if you look at the marking scheme, what he or she has done is actually answer to question 4. Should the examiners cancel question 6 and write the 4 there? Now, to these two dimensions of the problem, examiners are often divided. One school of thought will say that, okay, if the student has actually written the correct answer, just pardon the students, write the correct question mark there, and move on. Another school of thought, which I think is the strongest one, is that when it comes to examination, the rules are as important as the correct answer. So if the student has not indicated, give the student 0 for that particular question, or say that the student has deviated or whatever. So please, you don't need to let your case become one of these cases which will have to be settled within such a controversy. It's not necessary. You can avoid it. Don't let your fate, hang upon how a certain debate among examiners are going to resolve. That is too dangerous. And you have the way to avoid it. So just do the needful. Write your question number. And that's why I gave you the advice that when they say start work, when you have read through all the questions and then you've selected your 4 questions, put the points, right? The points that you need to respond to each of those questions down and write the question number against it. Then when you are developing it later on, you write the question number first before you develop it. Don't say that when I finish, I'll come back and write the question number. No. You may not remember. So don't take the risk. And don't let your faith hang up on how a particular debate will resolve among the team of examiners. That is too dangerous for this type of examination. Okay. Let me see who's on this up again. Okay, let's take Abigail. I don't know if I was able to address all, but if I've forgotten some answer, just prompt me. Yes, Salisu.
My Lord, thank you very much. I have 3 questions.
Okay.
One is with regards to the principles.
Okay.
And maybe in an area that is predominantly case law, let's take it torts.
Okay.
Then you are answering. The principle counts, but then you can't point the authority.
Okay.
How fatal is that? And the second one is on a statute-based course that you are answering, and maybe your strength is on the statutes. Then you use the statute to answer, and you're not able to apply the cases or use the cases.
Okay.
And the third one is also, some of us are not privileged with legible handwriting. The advice you have to give to us in relation to that. Thank you.
All right. Thank you, Salisu. So maybe let me start from the bottom, the handwriting. With respect to the handwriting, myself speaking to you, right from my primary school at Quintanas, St. George's Catholic primary school up to wherever I've been learning up to, my handwriting is not the best. But thank God, my handwriting is legible, meaning that my handwriting is not beautiful or handsome, however I want to put it, but my handwriting is readable. It can be read. So the point is ensuring that what you are reading can be read by another person, not you. So just put yourself, because for me, if I made even a scribble, I may make just a small scribble, but in my brain, when I'm talking, I can see a lot of things because it's just a symbol to point a certain knowledge in my brain. But you're not writing a news for yourself, okay? You are writing for somebody to read and understand what you want to say and what you want to mean. So please, maybe if your handwriting is really, really, really horrible, the advice would be to space out, okay? When you space out well, I think that it will enable your examiners, manage to read what you have. And also, Socrates said that man, know thyself, isn't it? Because the proper study of man is mind. Yeah, so know your situation. So if I know that my handwriting is not the best, all the time when I'm writing, that consciousness should be there. And having that awareness, it will help me to gradually make effort so that what I am writing can be read. Yeah, so I think that is the first thing. So I'm happy, Salisu, for example, has been very honest with his situation. So me too, I should also be honest with my situation and know that, yes, this is my weakness, yes. I learned hard, I'm supposed to be good and all that, but my handwriting is not great. But so anytime I'm writing, I have to make extra effort that what I am writing can be read. Yes. That is, and I said that if you like, one way to manage this is to actually reasonably space it out so that it will stand out, okay? And two, if you need to cancel something you've done, just cancel it once. Don't need to write and deepen it and expect your examiners to read what you have used the ink to deepen and all that. There's no point. Just cross it out and then write the next place available. Then he has a question that if you take like the case law subject, like law of torts, law of contracts, especially, which are heavily case law, that is to say that the principles of the law themselves are actually enunciated or espoused in the decided cases. Now, he knows the principle, right? He knows the various propositions, but then he has forgotten the name of the case in which the principle of law or the proposition of law was actually propounded. What should he do? Well, Salisu, my thinking is that where you actually know, okay, the principles of law, the proposition of law, or the rules of law, go ahead and write them. Okay? You can, for example, say that it is the law that, or the position of the common law is that, or it is a settled principle of law that, or where you very much remember that what you are saying is from a certain case. You can say that in a decided case, then you write. Now, if what you have written is really the principle of law, despite the fact that you've not been able to state the name of that case in which you derive the principle or the proposition of law from, you will still be given credit. You'll still be given credit. Even if not the full mark, you still get a reasonable mark because what you stated is correct. Yeah, so that is about that. Or sometimes it may well be that, for example, the case of Donogu against Stevenson, okay? You remember the case of, you remember only the first part, let's say Donogu. You don't remember the Stevenson. You can simply say that in the Donogu's case, case, where it was held that a duty of care exists whenever there's a proximate relationship and so on and so forth. Yes. So that is one way of going about it. Then the second one, but let me warn you, students. I remember some years ago in some universities where we used to teach, you get students fabricating, okay, making up cases, and they will, no, please. There's a difference between a decided case and a simulated case. Unless your question said that, especially when you're doing like an essay question, okay? An essay question, let's suppose that you have actually forgotten you've forgotten like the cases, but you have a reasonable understanding of the principles, and you want to do illustration of the principle that you are discussing, especially so if those illustrations will help you to drive home the point which you are making in that essay. There is something you call simulated example or simulated case or hypothetical or case. So where S published a false statement about Y on a WhatsApp platform group and all that, they may well be a case of defamation because the element of publication might have been satisfied, since it's not only S and Y who are on the platform, but we also have so many other people. Now, what I did is what we call like the hypothetical illustration or simulated example. I have simulated it. I have just I've used my own generated scenario to illustrate a principle that I have explained, or the principle that I have stated. Supposing I have forgotten all my case law, or I don't remember my case law, but then understand the principle. And because it's an essay, and probably depending upon what the essay is and all that, having stated the principle, I need to illustrate to achieve a certain effect. I could probably do that. Now, that is an essay scenario. You cannot do simulated example, or you cannot do hypothetical illustration when you're answering a problem-based question. No. If you did that, if I'm your examiner, I'll be very angry. And I'm sure so many examiners will be angry when you're doing a problem-based question and you use your own illustrated example. The reason being that the problem-based question is supposed to be a near-life scenario which you will be given. And you are supposed to apply the law as it is, like the law as in force, to respond to that scenario or that problem. So if that is the case, if you are supposed to solve a problem, why should we allow you to tell stories? We have a concrete problem. So how do you solve it? How do you advise the parties and all that? So that one is different from where you are, for example, been invited maybe to discuss or examine how a particular area of the law has evolved, or a certain reform which may be done, and so on and so forth. That one is different. That one is an essay. So in appropriate situation, you may use, let's say that the simulated examples or those hypothetical situation to illustrate a point or two, but not when you are dealing with the problem-based question. Then our friend also said that, okay, if you are dealing with the a question, and let's say that the question is in the area of the law, which is a heavily statute-based, especially criminal law. Because if you take a criminal law, let's say that about 70 to 80% statute-based, most of the things that you write. In the case, I'll even say even 90%, the cases are just there as illustration, or to help us to understand how certain provisions have been, either interpreted or that they have been applied in the scenario. So the questioner, Salisu, is saying that yes, my strength has to do with like the statutes. Yes, I know the statutes. I know the various provision, section 23, conspiracy, section 124, section 125, section 120, stealing, dishonestly receiving, and so on and so forth. I know all that, but I don't remember the cases which illustrate them. What should I do? That is his question. Yes, as I've indicated, and as you rightly also understood, if the question, the particular area is a heavily statute-based, then the emphasis is on the statute. The cases are there as what we call the supporting it. Okay, so where you don't remember like the cases, but then you have the correct provisions of the relevant statute supporting your answers. I think you'll be given, even not all the marks, you'll be given reasonable marks. Yes, I think that is a solution. I think that is an attempt to respond to what you said. So if there's any, okay, let me see, could just hand this up. If you have anything, put up your hand. As I said, this is a Q&A forum on anything. Yes, Kojo, is your hand up or the old one? Okay, let's see. You can release yourself. Kojo, I think you can unmute yourself if your hand, yeah.
Hello,
Yes.
my lord. Please, those of us who are writing in Kumasi, we are yet to receive our like sentence. So it's just 2 days to the exam. So
You mean your
do we
index
need to have
numbers?
any problem?
You mean your index numbers?
Index numbers we have. Index numbers I have, but the sentence.
Okay.
I know it's
Do you
we
know
chose
something?
come
Let
here
me
USD.
let me clarify this. Please, I'm not a member of those who organize this examination. Okay. Those of you who are familiar with my Ghana Law TV on YouTube channel, I've been doing this since the COVID time. Okay. I've been doing this since the COVID time to help students, preparing for law school entrance examination, or sometimes preparing for the LLB. I do it as a friend of student. I am not part of any official arrangement. So I'm not able to speak for those who organize this examination. I'm just, doing an open thing. Anybody at all can join. I'm not part of the General Legal Council. I'm not part of the IEC. And I'm not speaking in any official capacity. I'm just speaking as someone who has been a teacher many years and a former dean of law. Yeah, okay. Yeah, so that particular question, I don't have the ability to answer it because I don't know about it and I'm not part of those who organize this exercise. But coming back to a certain question, which someone has put up in the chat, before I come to those whose hands are up, the person said that, please, what if you remember the parties to a case, but you don't remember which one? Let me see. Oh, it's done again. Oh, yeah, you remember a parties to a case, but you don't remember which one is the plaintiff or defendant. Is it right to say in the case involving party A and B? Yeah, I think we've addressed this already. So let's say that if you even remember the name of one of the the parties, you can just use that. Just like let's say that in the let's say Republic versus Kojo, Kojo Jemfi or something. So you can say that in the Kojo Jemfi case. Okay. But if you say in the Republic case, that one is not very helpful. The reason being that there are so many cases involved, which is like the Republic against someone or someone against the Republic. Okay. Yes. Okay, let's see other hands. I think, Kojo, your hand is not up again, isn't it? So when you finish, then you lower your hand so that we know the new ones which are up. Okay, we have Akwasi Buachi. Akwasi Buachi, you can Release yourself. Because you can unmute yourself. Okay, because it seems not to be read. Okay. Yes.
Hello, can you hear me?
Yes.
I wanted to find out. So I wanted to find out if you could give a brief summary on the negligent misrepresentation of the contract law, so that at least that would help put me a little bit. Thank you very much.
Okay, negligent misrepresentation, law of contracts. Okay, so what is the law with respect to negligent misrepresentation in law of contract? First of all, as we remember, negligent misrepresentation is one of the vitiating factors. Of course, the main vitiating factor here is misrepresentation, and negligent misrepresentation is one type of misrepresentation. And again, we have to remember that initially, we had only fraudulent misrepresentation and innocent misrepresentation. It was just mainly after the case of LeBron against Helen Partners in the 50s that we came to have a negligent misrepresentation as another form of misrepresentation. And negligent misrepresentation is where there is a special relationship between the maker of a statement and the person to whom the statement was made. So the maker of the statement, the representor, and then the person to whom the statement was made, the representative, for example. There's a special relationship between them, and the special relationship is said that the maker of the statement in law is obligated to ensure that the statement he or she is making is accurate. And for that matter, if it is not accurate, and if he could have ensured that it was accurate, but for his lack of care in not ensuring that it was accurate, if the other party relies on that statement and he or she suffers injury or suffers a loss, that will be a good case for negligent misrepresentation. So as you notice in the LeBron against Helen Partners, it was about financial transaction. I think a company was going to grant advertising credit, run advert for its customer company on credit basis. But before doing that, it needed to be sure of credit worthiness of this customer it was going to run advertisement for on credit basis. So it requested the financial advisors of that company, as it were, to give an opinion, just like in modern days, and not because maybe like the credit report and so on, to give an opinion on this particular company regarding its credit worthiness before it could go ahead and place the advertisement. Now, this company did that. They sent their financial opinion, but then in the financial opinion said that yes, the company which they were seeking to give the advert for on credit base called the Super Limited was a credit-worthy company. Having done that, they put in a clause called the disclaimer clause. Disclaimer clause simply means that they were saying that regardless of whatever they have said, okay, they are not prepared to actually take responsibility if anything should go wrong, and that is it. So they went ahead, ran the advertisement on credit basis. In the course of time, this company, which has enjoyed credit, which has enjoyed the advertisement on credit and had to pay, have become bankrupt. So the money that they had to pay the company which has run the advertisement was, will be lost. And the company decided to sue the financial advisors. And then the court looked into it and said that, yes, if you look at the relationship between the company, that is a plaintiff, which was going to run advertisement on behalf of the third company, Isabel Limited, on credit basis, and you look at the financial services company, the accountants who give like the opinion, there was a special relationship in the sense that they ought to have known that the advice they were going to give was going to be used for making a decision as to whether to grant credit or not to grant credit. And the law imposed an obligation on them to ensure that they will exercise requisite or necessary care so as to give an accurate, opinion, as it were. Yeah, so negligent misrepresentation, that is how it is. Now, when it is made out, when negligent misrepresentation actually exists, of course, damages will be awarded. And when damages are awarded in order to take care of all the expenses, what we call it, the foreseeable damages or injuries, which have been suffered as a result of that. Because you made a negligent misrepresentation, we have suffered these losses. If it had not been for your negligent misrepresentation, these losses would not have been suffered. So let's take the Heidelberg against Helen Partners, for example. If it had not been for the disclaimer, which they put in the opinion, let's assume this disclaimer was not there, the company which ran the advertisement would have been entitled to recover all the monies the AC Power Limited, which has enjoyed the advertisement on credit basis, was supposed to pay, which it had not been able to pay because it had become like liquidated or bankrupt. That money will have been recovered back from the financial advice company, that's the accounting firm. So that is how damages will be awarded in that particular situation. Yes, I don't know if that assists the person who has a question, but I think there are some other answers. Yeah, I think we have Joshua. Okay. Okay, let's take one lady and we'll come back to you'll be alternating that to have a gender balance. Yes. Let's take a lady. Okay, Joshua,
good morning, Doc.
Good morning.
Doc, the case of the Headley and partners that you mentioned.
Yes.
Let's say in Dairy versus Pig, is it similar to that case?
No, Dairy and Pig has to do with the what they call fraud. Yeah.
Okay.
Dairy and Pig.
All right, then my next question.
Also remember, I think the Dairy and Pig, they did the they put up information in the form of prospectus, which they use to persuade people to invest in the company, telling them that they're going to use the money to expand the operations of the company, but that was not really what intended to do, and so on. So that was about fraud. Yes.
My next question is, Doug, I read in Land, Immovable Property, about Go Lightly, Kokomlemle versus Go Lightly. And I want to know if that case is a locus class case, please. And is it under Alodia or Yusufrat?
What did you read about Kokomlemle and Go Lightly and Ashrafi?
No, honestly, the fact escaped me and the holding. That is what I'm asking.
Okay. So what have you read?
it is a long time case that I read in one of the immovable property books, but the
No,
first
you know
escape.
something? Let me tell you
No.
this. At this stage, the purpose of this exercise is that you are learning, you have read the thing, you don't understand, or you have some different view. But don't just say that since you learned this in the law faculty, you've never gone back to it when you know you're writing exams on Friday. So the fact that, and I gave you a certain advice, I think many months ago, I did a video and I told you how you should go about the preparation. I said audit, and the audit meant that you list all the topics, right? Each of the subjects, let's say land law. So you've listed the topics, you've listed, let's say, that the various customary law interests which may be held. You've listed the various interests that may be held, for example, at common law or even under the new Act 1036, the Land Act. You've listed leases, you've listed this and all that. Then you ask yourself, if I take each of them, am I able to state the relevant principles, the case, or the relevant authorities? Now, when you are done with that and you see that maybe a particular thing, you seem not to actually have it, then you quickly go back, you take the relevant notes or the textbook or the law or whatever, and you revise. So that is how we go about it. Otherwise, something comes up your mind, you know, you don't remember it, you don't know it, you don't go and look it up. What about
Okay.
you go Friday and then the question is there?
Doc, I did not cite it where it's Golightly versus Asherifi.
Oh, okay, Golightly versus Asherifi. Yeah. So,
Yeah.
what did you read about it?
What I read about is that it's a family. It was a family land given to one of the parties to farm on it by a stool by the allodia. And then the fact really escaped me, honestly.
No, let me tell you, when it comes to customary land law, some of the cases, it's not so much about the facts, but it's about like the principles which were enunciated or developed. Yeah, so commonly consolidated cases or Golightly versus Asherifi. So what were the principles? They are more important than the particular set of facts. So what were the principles? But the good thing for you is that with the new Land Act, some of the things which previously we have to cite a lot of cases in order to illustrate certain principles of customary land law, they have just been enacted. So if you know the provisions of the Land Act, it may save you some of the trouble. And I want to believe that at this stage, you have looked at the Land Act. Have you, Costina? Have you looked at the Land Act?
The Land Act.
Yes.
Yes, actually the principle is what I'm trying to say, that it is a long time I've read it. So if you can
You know what
help
the
me with,
allodial title is?
yes, I know the allodial titles, Doc.
What is it?
The allodial title is the highest title when it comes to land, and they acquire the land through conquest, also through war, or a vacant land that is available that has been occupied by them.
Okay.
And they can also acquire it through purchase when they buy.
Okay.
We have the stool, the skin, and the family lands. This is the allodial that I know, please.
You know the what do you call the fee simple in the common law?
No, Doc.
You know the Asrifi case, a number of things were at stake, including whether the various things which are known under the English land law or English movable property law, such as the fee simple, freehold, and so on, whether those ideas are immediately applicable to our land law as it were. So it was in the context of that that the court went ahead to explain what we know as like the allodial title, the supreme or the absolute interest, which may be held in land at the customary law. And then later on, the famous case by the Oleno, which will go ahead to give the various characteristics or the various ways in which the allodial title may be held. Yeah, so that is about that.
Okay, thank you.
Yeah, but if you say the Asrifi versus the Golightly, you are not wrong to say there's also like the Kokomlemre consolidated cases. That is another way of
Okay.
referring to, in the sense that it was not just one case, a couple of cases which were put together and decided by the court. And that's why we call it the consolidated cases.
Okay, thank you.
But if you look at the Land Act, you know the various interests as listed in the Land Act. Yes, Cosina, I'm still on you.
Yeah, Doc, I'm here.
Have you look at the Land Act?
Yeah, the Land Act, yes, please.
Okay.
There,
Please, if you haven't looked at the Land Act, I will suggest that since you don't know whether there will be
Section 2 is on the allodial. The Section 2 is on the allodial.
yeah, so what does Section 2 say about allodial?
The Section 2 states that the highest or ultimate interest in land, that is Section 2(1), Section 2A.
Okay.
And then the B also goes ahead to state that the state or a stool or skin or clan or family or an individual, they have each acquired it through various means. If it is a state compulsory acquisition and all that, the family could be through settlement, gift, purchase, or agreement, or new discovery.
Right. Okay. All right. Good. Okay. Good. So let's take another person. Lisa. And then okay, Samuel Poku. The one who spoke was a lady. So let's take another man and come back to another lady. Yes, Samuel.
Hello, Doc.
Yes.
Yeah, Doc, thank you. The last time I joined your discussion late, but you were on illegality when it comes to contract and the effect of illegality, where you mentioned that you cannot claim under illegal contract. But you came back to the Ghanaian position and you cited Accra City Waste and AMA. And if I heard you right, then you meant that the position of the law in Ghana is represented by that case, that for some reasons of at equity, a person can claim so that to avoid unjust enrichment. Looking at that case, you can still claim under illegal contract. I think I wanted a little clarification on that and to know what is that. That is the position of the law in Ghana. If it's illegal contract, one can still claim under it.
Okay, all right. Thank
Thank
you.
you.
Thank you. Yes, so I made the point that at common law, where it is established that a contract is illegal, a contract is contrary to public policy, and money has been transferred under that contract or properly transferred, as a general rule, it cannot be recovered. But then we have exceptions. We look at if, for example, both parties are not equally guilty, that what they call they are not in pari delicto, then the innocent party will be allowed to recover. And we also made the point that where there has been locus penitentia, that is, has been a repentance or change of mind by one of the parties before the illegal contract was implemented, then the party who has had the change of mind will be allowed to recover, as it were. And then we also have what we call like the severability principle. Sometimes where if you can sever, you can take the illegal contract, illegal portion out, and then the other part of the contract will, for example, remain unaffected by the illegality, using the pencil principle, the severability principle, it may be possible. Then we made the point that, so what that means is that if you cannot bring yourself within any of these exceptions, that is the end for you. It is within that context that the Supreme Court, through the lead opinion of Justice Latiba, in the case that we mentioned, I think the Accra, Accra AMA against the CCW, that's the City and Country Waste Limited. As if you remember the story, we said that yes, there have been contracts, but for this City and Country Waste Limited to provide sanitation services, having done so, when it was time for them to pay, EMA sought to hide behind the fact that when it was entering into that contract, it didn't comply with certain statutory requirements and all that. And it was in the context of that, the court was saying that yes, if we look at the story as narrated by the EMA, yes, you will say that the contract was certainly an illegal contract because those statutory requirements have to be satisfied and all that. But the court said that if you are to adhere strictly, right? If you are to adhere strictly to what the court call like the technical approach, as we have been explaining, you are going to have unfairness or injustice, as the questioner also pointed out. The fact that there may be unjust enrichment. What is unjust enrichment here? Unjust enrichment, maybe those of you who are familiar with the Christian Bible, you know the saying that you are reaping where you have not sown. You need to sow, you need to plant before you harvest. But where you've not planted and yet you are harvesting, That is ill-gotten gain, isn't it? So AMA, you have not paid for sanitation service and yet you've enjoyed it. And someone has had to incur expenses for you to enjoy that. And you just get away with it. So that is unjust enrichment. And that is why the court said that it is necessary for that to be reconsidered. And the court opted for what they called a structured discretionary approach. And this structured discretionary approach, in the court view, was consistent with what was the trend around the common law world. Especially the court look at what the English Law Commission was doing, what the New Zealand Law Commission was doing regarding reforming this aspect of the law. So the court said that yes, it is necessary for Ghana to also embrace the structured discretionary approach. And what is a structured discretionary approach? That is to say that the court may adopt what they call the case-by-case approach, case-by-case, look at the set of facts, look at the realities of a particular case, and based upon the realities of a particular case, you are able to render an outcome which is fair and just, which will not result in unjust enrichment. Yeah, I think that is my understanding of that particular case. I don't know if that assists you. The question, you see there, I think it's gone. Was it? Okay, I think it's gone. Okay. So we have another person, Lord Catus. Yes, okay, Elizabeth Anim.
Hi, good morning. Good morning.
Good morning.
Please, respectfully, my question has to do with constitutional law.
Okay.
There had been a recent hula baloo about the decision by the Chief Justice to change the Supreme Court panel and even sit on the case, which has attracted some debate among a cross-section of Ghanaians. And assuming we are asked to discuss pursuant to Article 1573. My question is, this is
what article?
1573.
Okay.
So my question is, being limited, are we going to take it are we to take it from the perspective of constitutionalism, or to solely concentrate on the judiciary? Because it looks limited, just one article talking about that particular thing.
If I remember, I refer to the provision which says, without prejudice to clause 2 of this article, no person sitting in the superior court for determination of any cause or matter shall, having heard arguments of the parties to that cause or matter, before judgment is delivered, withdraw as a member of the court or tribunal, as a member of the panel determining the case or matter, nor shall that person become fontus officio in respect of that case or matter until the judgment is delivered. Is that a provision?
Yes, please, exactly.
And your question is?
And that the Chief Justice recently changed a panel with respect to a case at the Supreme Court, and even sat on the panel. So the previous judges having heard the matter and they being changed by the Chief Justice, the question is whether it is legal or whether it's not procedurally wrong per the Constitution.
All right. Okay. Right. So if I understand you, well, I don't know the specific facts that you are speaking to, but going by the generalized scenario, as informed by Article 157 Clause 3 of the 1992 Constitution, where a judge, right, where a judge, especially at the superior court level, has actually heard a matter, has heard the arguments, or has heard the evidence in respect of a matter, whether that judge can withdraw from hearing the case, or whether that judge can be removed from hearing the case. Don't forget, we have also what you call it, the rules of natural justice, okay? A judge can recuse himself. Recusing himself means that he himself is trying to withdraw from adjudicating the case. So let's suppose that a judge has heard the case, but just before he or she come to give the judgment, he or she, for example, has been involved in a way which his conscience tells him or her that his impartiality or her impartiality may be called into question if he or she should proceed to decide the matter. Then, regardless of Article 157 Clause 3, the judge will be able to recuse himself or withdraw from giving a judgment. Yeah, so that is one thing to note. And of course, in terms of the Chief Justice hypothetical scenario that you have narrated, as I don't have like all the facts, so I'm not able to speak specifically to that. We remember the decision in the old decision involving, I think, Kwasi Aidan, and also the old decision, I think, involving the Ghana Bar Association, and then Nutifafa, those decisions, where the Supreme Court makes the point that the rules of natural justice, for example, may have to give way to a certain constitutional necessity or imperative. If, for example, a duty has been performed under the law, under the Constitution, and performance of that duty will necessarily warrant the breach of, let's say, the natural justice principle of nemo judas in casa sua, that is, no judge have been a judge in his own cause and so on, then so be it. So, for example, you have sued the Chief Justice, okay? You sued the Chief Justice and all that. I think just as like it happened, not too long ago, under the 1992 Constitution and also the previous Constitution. And we know under the Constitution is the prerogative of the Chief Justice to impanel, that is, to build the panel to select who sit on which case. Okay, so if you have like the case is going to the Supreme Court, the case is before the Court of Appeal and all that, the panel will be built by the Chief Justice, as it were. Except maybe like for the High Court, you have like judges sitting at the various High Courts already. So apart from extreme cases or transfer or something like that, when the case is assigned to the court, there's a judge there already. But apart from that, if you take the Court of Appeal, you take the Supreme Court, the judges of the Supreme Court and judges of Court of Appeal, no one knows what case he or she will sit on until you have been invited by the Chief Justice that you'll be put on a particular panel. So, and under the law, it is her or his duty, whoever the Chief Justice is, to do that. So, even if the case involved the Chief Justice he or she will have to play that role. Yeah, so that is the other thing to remember. Okay. I think so. I think that those are the few comments I can say about that. Is there any hand up? But the lady who has a question, yes, I don't know if that assists you a little bit. I think that was Elizabeth Tanim. Yes.
Yes, please. I'm okay. I'm okay. I was actually this actually helped me because I was actually thinking it's going to go through constitutionalism where there's going to be procedural limitations, where you have to go by the constitution where a procedure is specified in the constitution.
Right.
Yeah.
Right. Okay. So let's take Lord Catus.
Thank you, my lord. Respectfully, my lord. Cases like Martin Pebu and Attorney General. You know, we have number 1, number 2, number 3, number 4. Number 2, which talks about all offenses being bailable. And number 4, when the police cannot hold somebody behind bars for more than 48 hours without sending them to court. I want to know, under examination conditions, when you are hard pressed, it's easy to remember now that there's no pressure. The numbers. Can you just state Martin Pebu versus and the AG and make the principles, like write the principles down without stating the numbers? Would that be accepted?
All right.
Yes.
Okay.
Thank you very much.
All right.
Yeah.
So good as a good challenge which may come up. Yes. So where you have multiple case law involving the same parties, so to speak. So as you said, Martin Pebu number 1, number 2, number 3, number 4, and number 5, and so on. You don't remember whether it is number 2, which, for example, say that maybe section 96 or 98 of the Criminal Procedure Act is unconstitutional insofar as it says that certain offenses are not bailable and some are bailable and so on. But you know what the court said, you understand it, but you don't remember the number. Yes, you can simply say that in one of the Martin Pebu cases, right? In one of the Martin Pebu cases, it was held that, I mean, that is all right. Because if we go to the marking scheme, Martin Pebu is there. Despite the fact that Martin Pebu, it will have been specified maybe Martin Pebu number 1 or number 2. But then the fact also remains that Martin Pebu is indicated in the marking scheme. Yes, we have, I don't know. Yes, Elizabeth, you want to say something? Okay, so let's take Benjamin.
Thank you very much for the opportunity. My question borders on a conspiracy. And from my reading, I came across an article that suggests that the law on conspiracy has been changed or reformed in Ghana to the effect that you don't need to prove any prior agreement. So please, I want you to expatiate on it for me.
Okay,
Thank you very much.
Okay. All right. So when we say that you don't need to prove any agreements with respect to the law of conspiracy under criminal law in Ghana, I think there's a feedback. I don't know if it's from my end. Yeah, good. So when you talk about agreement, we'll be thinking that yes, both of us should actually be aware that we've agreed to enter into a particular act or conduct, as it were. No, it's just the understanding of the section 23, which has evolved. That is to say that the acts, right? The various acts of the parties. You may not even know each other. You may not know each other, but then when your acts are considered together, when your acts are synchronized objectively, and if we notice that, yes, you're acting together or you're acting in concert, with or without agreement known to each other to do the particular crime, to commit the particular offense, that will suffice as far as the law of the conspiracy is concerned in Ghana. So it may well be that, yes, you are in Kintampo, for example, on, let's say you'll be writing certain things on the social media that the National Cathedral, let's assume the National Cathedral is completed, right? You are saying that, yes, the National Cathedral should be blown up or something like that. And somebody in Accra, for example, should go and blow up the National Cathedral, okay, in Accra. Now, despite the fact that you were in Kindampo and you have not actually come together with the person in Accra who went to blow up the National Cathedral, we can still piece your acts together and say that you conspired to actually create that arson or to create that particular crime of destroying that national asset, as it were. Yeah, so that is how it is. So in that case, the agreement may be implicit or explicit. And what I pointed out, for example, is implicit. Implicit in the sense that you have stated on the social media, which can be accessed by everybody, that this particular crime should be done, or we are going to do it. And somebody picks what you have done and actually goes to carry it out. So there's that implied agreement, or you are working together, as it were, to commit that crime. And that could suffice as a conspiracy. Yes, I don't know if that assists you. So if we are talking about the agreement in the formal sense, no, then not necessarily that. It can be very informal, very implied, and so on. But the most important thing is that two or more parties are working together, or even objectively are even seen to be intending to commit a particular crime. Okay, you don't have any hand up again. Yes, any other? Okay, let me see. Okay. Any hand up? Ooh, okay, we have Frederick. And then Frederick, you can mute yourself.
Okay, sir. Thank you so much. Sir, please, I am asking because I'm sure maybe somebody might have asked, but I came a bit late. Recently, we've seen lot of formula for the solving of the problem question, but then we go by what you've taught us already. And if I remember correctly, you made us understand that if you have multiple issues or from what you've been learning.
Before you go on, you said you've received many different ways of solving the problem. Can you share that with us so that we can comment on
Yes,
it?
please. Okay. So thank you, sir. I think there are variants. Some people decide to use the IRAC by raising all the issues. When they finish, then they would set out all the laws. Then they will do that.
Oh, we've lost him. Are you there? Are you there, our friend? We've lost him. Let me see. Okay, Frederick, Frederick, are you there? Frederick? The mic is somebody we can't, and he seems not to be talking. Okay, Frederick is not there if anybody is ready. Oh, Frederick, I think his network is failing him, so he's off. Frederick, I think Samuel.
Doc, once again, Doc, we've recently heard of this matter of plea bargaining. Just a little bit of your perspective on what this is, because it's a new phenomenon in our legal system. What's the concept and what about this plea bargaining and whether it is
Okay, all right,
something.
good. I think the last year or last 2 years, if I remember, there was a presentation which was done on this. We have the video on the Ghana Law TV. So when you go to Ghana Law TV, just maybe type plea bargaining in Ghana or something like that. I'm sure you get like the full presentation, but at this stage, I'll just be give you the sketch. So the idea of the plea bargaining is it's part of our law, for a long time, except that it will be given like a new and a more elaborate emphasis, as it were. And the idea is that where you will be charged with a particular offense, you can, for example, accept liability or responsibility for either that offense, so that you don't have to go through the full gamut of, prosecution, the prosecution bringing evidence, going through the usual trial, examination in chief, cross-examination, re-examination, and the prosecution call the witnesses and the various drama, associated with the trial, objections, and so on and so forth. Prosecution will finish, and then you have like what you call like the submission of no case. Then the defense or the case will say that he or she thinks that the prosecution has not established a prima facie case to warrant the accused or the defense open his or her defense, and for that matter, he should be acquitted and then discharged. You go through all that, the court will either uphold the submission of no case, or the court may dismiss it. Then the one side may want to appeal, as we saw recently in the Atufosin's case, which went to the Court of Appeal. And the Court of Appeal, for example, reversing decision of the trial court to dismiss the submission of no case, and let's say the prosecution will also go up to the Supreme Court. So let's assume that the Supreme Court also disagrees with the Court of Appeal, then you have to go back to the trial court for the trial to continue and all those things. So to avoid all that, it is a public policy, intervention that if a person charged with a crime is prepared to cooperate with the state by conceding to the wrongdoing and so on, so that the state will not have to deploy its resources and go through all the the various things that I have mentioned, then that accused person should also enjoy some leniency or some limited clemency from the state. And that could include either the accused person being given a lesser punishment, okay? The accused person may be given a lesser punishment for the offense, or the accused person may be charged with a lesser crime. So let's suppose that, yes, you've done something, you could be charged with a very serious offense, but you concede to doing certain facts, and those facts can also support some other charges or some other offenses, which are relatively less in terms of severity of punishment and all that. Then because of your cooperation, that may also be done as it were. So that is about it. But not all offenses are amenable to plea bargaining. For example, if you have committed let's say that like the terrorism, piracy, hijacking, and so on, they are not amenable to plea bargaining. But fundamentally, as I said, the idea is to ensure that an agreement is reached between the accused person, the state, and sometimes the victim of the offense regarding the particular offense. And once the agreement is reached, it's brought to the attention of the court, and the court will adopt it, and that will end the particular offense. This was made possible as a result of the amendment of the Criminal and Other Offenses Procedure Amendment Act 2022, Act 1079. So Act 1079 amended Act 30. Act 30 is about the Criminal Procedure Act. So let's keep that in mind. Good.
Thank you.
Yes, that assists too. Yeah. Is there any hand? So maybe just to be sure, murder, if you've committed murder or you're charged with murder, that cannot be subject matter of plea bargaining. Genocide, just genocide can also not be subject matter of plea bargaining. Of course, treason can also not be a subject matter of plea bargaining. And any offense which is punishable by death, as it were, can also not be subject matter of plea bargaining. There any other? Let me see. Yeah, there was a gentleman who has a question, and I think he's out. The sad thing about what you're doing is that once, because the capacity is at 100, if you leave, you may not be able to join again, because if somebody joins and we hit 100, then you cannot enter. So that is how it is. So sorry. We have Joseph. Yeah, Joseph, can unmute yourself.
Thank you, Dr. Ennis. Okay, I think I just want to reiterate what Frederick Amoesi was saying before he had network hitches.
Okay.
Okay, so his major concern was about the standardization of IRAC. So in simple terms, which IRAC is the best format to be used for the entrance exam? Because over the years, we realized that people come with different approach when it comes to the IRAC, which earlier he was stating that some will prefer stating the area of law and they will give the issues. So they'll give a list of issues before they give the rules applicable and they apply to the issues in that regard. And the other people are also suggesting that you still state the area of law though, then you, instead of listing the issues, you just go ahead with issue one, whether or not, then you write the rules, you apply, you conclude. Then you do same for all the other issues. Then after you give a general conclusion. And the other people too are also saying that you still state the area of law, you state your issue, and instead of saying whether or not, you just say as to whether or not, and you still write the rules, then you apply, you conclude, you do same for all the other issues, and you give a general conclusion. So in your candidate opinion, Dr. Eniso Usudapa, we want to find out from you, what should be the best standard approach for using IRAC? And also kindly touch on essay, the best standard approach for approaching an essay question. Thank you.
All right, thank you. With respect to the problem-based question or scenario or case study type question, as you rightly said, we solve it in a way that judges and lawyers think about problems. We use a structured approach. And that structured approach is what is variously called as IPAC, IRAC, IRAC, or whatever you call it. But to the question as whether there is any particular preferred approach in doing this, my answer is no. However, examiners would like students' response to be very structured. We like students' response to be very structured. And being structured means that let it come out clearly in your answer that you have recognized the particular principles, the particular issues, that's the particular questions of law, which need to be addressed in order to resolve that particular problem, okay? And of course, as whether somebody will write the area of law or someone will not write it is not really a big deal. But what is a big deal is the raising of the issues. The raising of the issues are very important. If you write the area of law, it's good. If you don't write it, it's not so fatal. But if you don't generate issues, if you don't raise issues, then definitely you lose marks, because some reasonable marks are often allocated for raising the issues. So if you've not raised the issues and then you just started talking generally, the examiner may just exercise his discretion and just give you just one point of the many issue, which may be given you for the issues or something like that. So that is why it's better to go about the systematic approach. And as to whether you should do this particular way that you have all the issues, I will prefer you have, even if you are going to mention the area of law, fine, mention it, and then raise all the issues, okay? As part of your introduction, all the issues are canvassed in your introduction. And then having done that, you take one issue after the other, or in some cases where you have one or two related issues and they may have to be resolved together, then you take them and then under them, you state the relevant principles of law, and then you do the analysis and application, you conclude on that, then you take the other issues. So that is one way. On the other hand, some students may also go about it the other way, and which is that other way, as he said, all the issues are actually listed or identified, and then they will narrate all the principles, right? All the principles and the relevant case law in one breath before they come to resolve the issues. So that instead of stating the principles under each of the issues, they may just state all the law in a one long narration, and then they come to resolve the issues together. I mean, that one is also good. However, the point to remember is that you must address the elements in what we call the IRAC or the IPAC. That is, you must have area and issues or the issues, and then we must see the principles together with the relevant case law, and we must do the application analysis and conclude on it. So this element must run through your answer. So once they run through your answer, if you want to do it my way, that is you taking the issues and then setting the relevant principle and applying them, or you want to do it the other general way, listing all the issues and then stating all the principles together, right? Together the case law, before we come to do the application analysis of the various issues in seriatim. I mean, that is also fine. That is also fine. But don't make the mistake of ignoring the elements, right? And then just start talking about this person has no case because this will have been done, then you just start talking like that. No, that one is no good. But so long as you are mindful of the elements of the IRAC or the IPAC, as we have explained, you are free to choose whichever way you think is good for you. I don't know if that assists our friend who continued the question. That is yes. I don't know if that assists you. Okay.
Yes, please, it does. And we also want to know the standard approach for approaching the essay questions.
Okay, good. So for essay question, one thing about students is that if you tell them something, then instead of tweaking or adapting what you have said to suit the various situations or questions that they'll get, they will let it become like the one size fit all. So you see a student writing, some examiners, you see a student writing, this question is an invitation for me to do so and so and so and so. And this is running through all the answers. And it gets a bit boring. But the point about essay is that an essay must also be structured. If for nothing at all, every essay has three main parts. The essay has introduction. And what is the introduction supposed to do? Introduction is supposed to tell us about what the essay is going to speak to. What is the essay going to explore? What is the essay going to discuss? So it's a bit like a roadmap, isn't it? So when the examiner has read your introduction, the examiner must have clear understanding that, yes, if there's a certain key term or key concept in the question, your introduction will have actually explained or defined and also tell us what other things you are going to do in your answer. So that is introduction. Introduction, you are giving us an overview of what your answer is, isn't it? And that overview, of course, will include helping us to understand any key concept or key term which may be contained in your answer or the question as it were. Now, in terms of like the body, depending upon the question, it may be useful to have sub topics. You see, it may be useful to have like the subtopics and maybe as part of your body, depending upon what the question is. So let's suppose that you have a question which is asking you to, for example, discuss modifications which have been made to the common law doctrine of consideration under Ghanaian law. Okay. So you have an introduction which would actually tell us briefly what the consideration is, and then you tell us what you are going to do. So you have told us that, yes, in this write-up or in this, you are going to tell us what the common law position was, with respect to this and this and that, and then how it has been modified by Ghanaian law. So that is your introduction. Then you take, let's say, subtopics. For example, when it comes to, let's say, performance of an existing contractual obligation. So that is a subtopic. You tell us what does the common law. The common law was that, yes, if that was done, if you rely on the existing performance of existing contractual obligation, that could not be a good or sufficient consideration. So that is the common law position. What is the position under Ghanaian law? What is the position under Act 25? Then you tell us that under Act 25, you mentioned the relevant or the provision, that can still be a good consideration. Then you take another one. So that way, you have a bit of like a structure, and it's easy for the examiner to follow your answer. Or if you are not using subtopics, you have to use the word like, first, in the first place, or secondly, thirdly, and so on. So that when you are moving from one point to another, we can follow the transition, okay? We can follow the transition. And of course, when you are done, you must have like a conclusion. So the conclusion is pulling together everything and then telling us your short answer. So yes, has there been a change to, let's say, the common law doctrine of consideration? The consideration will answer that. Yes, the Ghanaian law has not retained the common law doctrine in its pristine form. And as has been demonstrated above, there has been some important changes or modifications. So be it, you are done. So essay question, every essay question must have like a introduction, And then you have like the body, as I said, the body, two things, either you use subtopics, okay, or subheadings, or you have to use what you call the paragraph transition markers, like in the first place, or firstly, secondly, or first, second, third, fourth, fifth, sixth, or besides, furthermore, moreover, you use those things for us to know that you're moving from one point to another. Or in some cases, you may even, depending upon what you're doing, you may even write a 1, 2, 3, 4, 5 as part of it, to depend upon the particular type of question you are dealing with. Okay, I don't know if that assists a little bit. Yes, so we have okay, so Samuel, okay, and then Benjamin. Yes, yes.
All right. Thank you very much for the opportunity.
Okay.
Please, my question is about the IRAC. I want to find out, when you are asked to advise the parties, are you supposed to, contain advice in the conclusion? We need to give a conclusion and then you advise. Thank you.
Okay, are you to advise the, can you say it again? I think the thing is looking okay. I'm doing it this way. Please, I've opened the mic, but despite the fact that the mic can be opened by everyone, let me call you before you release your mic. Okay, so the mic is released, but don't release it on your own unless you put up your hand in and I mention your name. Thank you. Yes, so are it Benjamin or Samuel? Who was somebody? Yeah.
Please, it's Benjamin.
Right.
I want to find out with the IRAC.
Yes.
You're supposed to give a conclusion and you are supposed to advise the parties. So I want to find out if you should write the conclusion before the advice, or it should be part of the conclusion, advice be part of the conclusion.
All right, good.
Thank you.
As a matter of fact, when we talk about the advice, the whole of the exercise you are doing from the identification of the issues up to the very end is part of the advice, except that the advice here, if you like, is understood in two senses. One sense is about like the entire process you have to walk us through, and another one is about the takeaway. So your putative client, the client, he is not interested in all the plenty analysis you would do as a professional. What he or she is interested in is that regarding what has happened, can he sue or can he not sue? Has he got a claim or has he not got a claim? Has he got the defense or has he not got the defense? Yeah. So you having gone through all the various analysis and then the conclusion, the advice will be part of the conclusion. The advice will be part of the conclusion. Yes.
Thank you.
Okay. Samuel?
Yeah, hello, Doc.
Yes.
Doc, in answering an essay question, specifically when you are asked to give an opinion about an issue, maybe promissory estoppel, where we are aware that the Contract Act has made significant or substantial modifications to it. Do you conclude that based on the statutory inroads or modification, the concept is no more relevant in Ghana because of the Act, or you say something else? That's what I want to be clear about.
Right.
Thank you.
Okay, good. Yeah. So promissory estoppel, as we remember, promissory estoppel is a development from equity, and it has a background. As you remember, like the history that Denning Trace in the central landing property against the high trees case, what you call the high trees case, when he went back to the Howell Securities against Hughes from the old House of Laws decision, the old decision in the Jordan and Money and all that. The point simply me made is that in equity, if you have a legal right or you have a claim against someone and you create an impression to that person by a statement expressly made or by conduct unequivocally put up, that is unambiguous conduct or unambiguous statement, so to speak, and you expect the other party to believe or rely upon it, and he or she believe or relies upon it, and later on you want to make a demand, right, from that person, which suggests that you never made such impression or you never made such a statement or that conduct, then equity will consider it as being unfair and unjust because you freely created the impression, you freely created the statement or the conduct that you are not going to insist on your straight legal right, or you're not going to exercise your right for the time being and so on. So it is inequitable. It is not fair for you to be allowed to deny a clear impression that you had previously acted. And that is why equity will say that you are a stop from denying that you created that such impression. You are a stop from going back on what you said you'll not be going back to, and so on. So that is the idea. Now, in relation to law of contract, this promissory estoppel actually became relevant as a strategy, as a device for solving a problem created by the common law insistence on consideration, fresh consideration, when there has been modification of existing contract or variation of existing contractual right. As you remember, the common law position was that if there was a contract, you have obligation under it and so on, and you wanted to modify or vary it. Now, your variation of it, your promise to vary it or whatever, would not be enforced against you unless the other party who was seeking to enforce it against you could show that he or she provided consideration, he or she did something in return for that promise you had made to vary your existing contractual obligation. So in absence of that, that could not be enforced. So that was the scenario as we saw in the context of part payment of debt. So part payment of debt simply means that somebody is owing you, let's say, 500,000 Ghana cedis, and you tell the person that, that you are not going to demand the 500,000 if you or she will pay, let's say, 200,000. Now, common law, you are promised to waive or to forgive the remaining 300,000 is, for example, not binding unless the other party will show that he or she did something in return for your promise to forgive the remaining 300,000. So that is what we call the rule in the Pinel's case or the Fox and Beer. Now, later on, Denning looked at it and said that inequity, it has long been the position of the law that if a person by his own free act has made the other party against whom he could exercise a certain right to believe that will not exercise it, then if the other party relies on it and order his affairs, reliance upon it, the one who would have actually exercised the right will be prevented from going back to say that he never created that impression. So that is the promissory estoppel. As you saw in the first of the high trees case, the rent being reduced for the period of the war, and after the war, the landlords trying to demand the other party, I said, will not be demanding. So how the court resolve it. Now, in Ghana, if we are talking strictly in relation to, let's say, waiver of debt, okay? Now, when you have waived a debt or when you've decided to forgive a debt, as whether promissory estoppel is applicable or not applicable, the proper understanding is that by reason of the Contract Act, I think, I don't have my legislation with me, but by reason of, I think, Section 8(2), I think the Section 8, Section 2, which says that, yes, if you are promised to waive a debt, that promise is, for example, enforceable with or without consideration. So be it. So that, when it comes to part payment of debt, I mean, promissory estoppel is not really what do you call that, a problem, because already we have a statute which says that if you have promised to waive a debt, that promise is binding, even in absence of consideration. So that is it. But outside part payment of debt, let's say that when it comes to other modification of contracts, okay? When it comes to other modification of contract, promissory estoppel will be applicable. And in fact, if you look at Section 26 of the Evidence Act of Ghana, at the NRC 323, we know that there could be estoppel by conduct or you make like a statement, isn't it? So that is applicable. But when it comes to the specific instance of waiver of debt or forgiving part of a debt, then as I indicated, Section 8, I think subsection 2, has already provided the solution. And if there's a statutory solution, you don't need to go to equity or common law for a solution, because equity or common law is important where there is no statutory solution as it were. So let us keep that in mind. So for example, okay, I've located the provision now, which says that a promise to waive payment of a debt, okay, or part of a debt or performance of some other contractual or legal obligation shall not be invalid as a contract by reason of the absence of any consideration therefore. Yes. So even Section 8(2) is a solution, but the problem we've had with promissory estoppel has to do with how it has been taught in our various law of contract classes. You see, because at the time, promissory estoppel was actually promoted by the English court post high trees case, and then the Tools Tungsten case and so on, and the ELS and NASA and all that. English law, they don't have equivalent of our Section 8, subsection 2. English law, they don't have equivalent of that. But we, since 1960, we have Section 8, subsection 2. And Section 8, subsection 2 simply says that when it comes to promise to waive a debt, promise to release somebody from performance, contractual duty, or some legal duty, that promise is binding, even in absence of what? Consideration. Yes. Any other?
Doc, so coming back to the question that I posed, if the question solicits your opinion about whether promissory estoppel is of relevance in Ghana because of the Contract Act, will it be accurate to conclude as a law student that no, because of the Contract Act, promissory estoppel is of no relevance in Ghana? That's my concern.
Like if, as I said, in relation to specific scenario of variation of a contractual duty, then Section 8.2 simply says that it's binding. So what promissory estoppel is seeking to do is already achieved by Section 8.2. But as I said, because of Section 26 of the Evidence Act, some other legal context, it may still be relevant.
Okay.
But
Thank
if,
you,
if it's in relation to modification of contract, I think Section 8.2 provide a direct response that, as I quoted, let me get a provision again, that if you have the provision. Trying to get Section 8. Good. So Section 8.2. Section 8.2, a promise to waive the payment of a debt or part of a debt or the performance of some other contractual or legal obligation shall not be invalid as a contract by reason only of the absence of any consideration therefore. And here, if you read Professor Donna Harmon's old article on the modification of the doctrine of consideration by the Contract Act of 25, you know how she was at pains to emphasize that if the only reason for which you are going to say that a certain promise is not enforceable is because of absence of consideration, then it is the Ghanaian law that such a contract is what is enforceable. So here the emphasis is on the consideration element. All other things, okay? All other things, for example, that there should be intention to create a legal relation, there should be capacity, there should be what, it should not be illegal and all that. All those elements are supposed to be met with respect to the promise to vary existing contractual or legal obligation. The only thing which can be excused is if you cannot show consideration, then Section 8.2 is saying that it's still binding. Okay, now with respect to Ghana legal system and legal method, students will have to appreciate these topics well. The doctrine of the judicial precedent. Of course, you must also understand the civil procedure, basic of civil procedure, and then the criminal procedure. If we look at the volume 2 of my book, this has been well discussed over there. And those who also have like the volume 1 and the volume 2, let me also advise that a number of questions have been set at the end of each chapter. So if you can work yourself through all those questions, I am very sure that there will be no question on the Ghana legal system and legal method which you cannot answer, okay? Yeah, so you have to look at that. But if there are specific questions, we will deal with them as we bring them up. So that is why we are here. So I'm not seeing any hand up. So if by the next 5 minutes there are no questions or comments, I will be leaving you and come back to you another time.
Hello, Doc.
Yes.
Thank you so much.
Yes, please go ahead.
On our various platforms, at least to have the chance to listen to, it will be beneficial to us. And
I think the line went down, so I just heard on various platforms. What did you say? Yeah.
I mean, I'm suggesting that this recording, some of us had network difficulty in joining earlier.
Oh, okay.
Yes, sir. And at the time we wanted to join, it was full. So I want to suggest that after this, if you can soon enough take steps and put it on our platform, it will be beneficial to us.
Okay, I will try.
Yes, sir. The second question I wanted to find out is, for example, in criminal law, either criminal law or constitutional law, where you are to state a case that involves the Attorney General, will a student be required to write the Attorney General, or he can abbreviate it to say AG, MPP versus AG or something like that? Is it acceptable? Or you have to write the whole heading or something like that in terms of the citation set?
All right, thank you. Yeah, so if you write AG in capital versus Asari, or no, Kojo Kwaten versus AG. I mean, if you, that is fine, because but it has to be capital. The AG should be capital. But one who have preferred that you write the Attorney General in full first, but if you write the AG in capital versus core number 1 or whatever, or Sam number 2 versus AG, that is acceptable.
Thank you.
Right. But what is not very helpful is if you write in the AG case. Because if you say in the AG case or the Attorney General's case, there are no hundreds and probably thousands of cases involving the Attorney General in various areas of the law. So it will be difficult for us to know which one you are talking about. Okay, I think we seem to have exhausted this session. But since you don't speak next session, when I come, I'll just raise questions and just discuss the questions with you. When I'm done, then I'll allow you to ask questions if you want. Okay, so have a very good afternoon and wish you all the best.
We are grateful.
Okay, Ibrahim, before I go.
Thank you, Doc.
Yes, Ibrahim, your hand is up. Go ahead. Oh, Ibrahim, your hand is not up. Okay.